Feeling lost in the maze of CPS? Desperate to get your child back? You're not alone. Countless parents face the heart-wrenching reality of family separation. The legal system can be overwhelming, but there's hope.
Now, here's the key. Okay, that's how you win a 6-month hearing.
Thank you.
If you do all of those things, you're going to blow your social worker's mind, you're going to blow your attorney's mind, and you're going to blow away the judge.
With attorney Vincent W. Davis, a dedicated legal expert with 39 years of experience, committed to helping families like yours. Join his weekly live Q&A on Zoom, where you can ask your burning questions about CPS cases. Get the knowledge and strategies you need to fight for your child's return.
Alrighty, good evening everyone. This is a question and answer session for school, SKOOL, and this is the CPS school.
Are you ready to take control of your family's future? Join our school community for free to access weekly live Q&A sessions, or participate as a one-time guest. Don't let fear hold you back. Take the first step towards reuniting your family. Join us now.
Good evening. Oh, good afternoon. Good afternoon. Good afternoon. Tessa, how are you?
Could be better, but I'm doing all right.
Okay, I understand you're from Los Angeles, California?
No, I'm from Redding, California.
Oh, your case is in Redding, not in LA.
Yes.
Okay. Actually, your case is in not Redding, it's in Shasta County.
Yes.
Okay. Have we talked before?
I believe we did already talk a little bit, but we didn't do your live show.
Okay. So what's going on? What questions do you have for me today in the office hours?
Well, my main question is, it's an odd one. If the individual that says they saw something and that's what they were going off of by CPS, and then we go to trial and he changes his whole statement, wouldn't that change their jurisdiction to remove my child?
No.
I mean, no, because he claimed he seen domestic violence originally in the report, and then at trial he says he never seen anything. He doesn't know what happened.
Well, typically when that happens and the witness changes their testimony in your favor, that means you'd win the case and the case should be thrown out. Now, there could be a situation, and I've seen this before, where the witness changes their testimony at the time of trial in favor of the parent, and then the judge says, well, I don't believe the witness. I believe the social worker when the witness originally told her he's seen domestic violence.
Okay, because
in your case?
Kind of, the guy claimed that we had been arguing and fighting, and he called the management of the unit we were living in. Management called my housing support worker, and she called the guy claiming to be a social worker of the state and got him to say a bunch of stuff that he now says, oh, well, that's not what I said. I didn't actually see anybody hit anybody. I just heard yelling and seen him from his backside. I didn't actually see her. But the statement he gave her was that he was beating me.
Right. So now he's changed his testimony, and it sounds like the judge has decided not to believe him this time when he's on the witness stand.
Well, what they did at court, we have 2 more days of trial coming up at the end of the month for the 31st and the 5th, because the child's attorney and the social worker's attorney claimed they didn't get the 355 denials or the objection, the 355 objection. However, the judge told them, well, you should have got it because they did it on such and such date. And we only took that individual person's witness testimony, which I have my minutes here, and it doesn't even have his testimony in it.
Well, the minutes won't have the testimony in it. All the
No?
minutes will,
Okay.
no, all the minutes will do is say that John Doe testified. The court
Oh.
reporter's transcripts will have all of his testimony.
Am I able to get those?
Absolutely. You have to ask your
Okay.
attorney how to get them, and you order them. You get a court order, and then you order them from the court reporter, and the court reporter will
Okay.
prepare them for you and give it to you. Now,
Okay.
there's two different ways you can order it. Regular, which means that you'll get it, maybe within a couple of weeks, or you can get it expedited, which means you can get it overnight. I don't know if you need them. Sometimes in trials, especially criminal trials, they do something called dailies, where you get the testimony every day. The court reporter's transcripts every day.
Right. Okay. That's interesting. The other question that I had was, you had made a point in your videos to don't let your public defenders not do their job. She got upset with me because I filed petitions or subpoenas, and she didn't want me to. She said that they were too expensive. And I told her, well, that's not my problem. I need them because they're professional witnesses. And even the child's attorney didn't want them there. That's part of the reason we requested a continuance for the trial, because I have a neurologist, I have a therapist who I've been working with for almost 2 years, and I also have the sheriffs that came out the day of, checked me and my son out. My son even held the sheriff's finger, and he said everything was fine. They didn't want any of them there. I put my foot down and I was like, hey.
Obviously, the minor's attorney and the social worker's attorney would not want them there because there's favorable testimony for you, right? And by the way, somebody else told me this about the public defender saying, I can't bring in that witness. It's too expensive to subpoena. I actually looked that up. That's improper. That's not a basis for not bringing in a witness, and it's tantamount to what's called ineffective assistance of counsel. And it also isn't true, because in juvenile cases, the sheriffs will serve your subpoenas for free.
Right.
So it's no cost to the attorney other than drawing up the one-page form, the subpoena, for that person to be present. That's about a 10-minute
I could
job.
do it myself. That's why I did it. I do have a big question, though. They are trying to give me a social worker that I have a past with, and she has a huge bias against me. Is there any way I can address that?
Yeah, in the
like, this woman won't give me my kid.
In the Welfare and Institutions Code section, I think it's 13,500 or thereabouts. You can make a motion to have a social worker disqualified. And if you believe that she will not promote family reunification, that you have a personal, conflict with her, or she has a bias with you, you can definitely get her disqualified. Now, you have to make that motion. You have to make that motion, and the judge has to grant it. But if the judge doesn't grant it and you don't get your children back, that's just another issue for you to appeal.
Right. That's what I was wondering, because I've worked with this social worker in the past, and she is evil with a capital E. She does not.
So when you make your motion, you have to have a declaration supported by specific facts of why she's evil. Saying that she's evil is just a conclusion that has no evidentiary value. You have to say she's evil because this is what she did to me in the past. 1, 2, 3, 4. She's evil because this is what she said to me in the past. 1, 2, 3, 4. She's evil because this is what her body language and her attitude has been like with me in the past. 1, 2, 3, 4. You have to give specific things that you've seen, heard, felt, with your senses.
Okay.
Okay?
Yeah, because me and my husband, we've already made it very clear we will not go to a CFT with this woman unless we have our attorneys there,
You know,
because she will twist everything.
I don't know if you know this, but you don't ever have to go to a CFT.
So one of the cats are
We
bleeding
don't?
profusely.
It's not required by law.
They
Especially
told
at
me
the-
that we have to attend them, otherwise it looks bad on us. They could use that against
Well,
us.
Okay, well, that's something totally different from what I just said.
Right.
I said you don't have to go to a CFT.
I'm
Will the
terrified of
judge
this lady. I ain't
will
showing
the
up.
will the judge look
I'm a 42
negatively will the judge look negatively on that by you not going?
Right.
I don't know. Depends on how, a lot of judges, I've come across a lot of judges that believe that you have to go to a CFT. And post disposition, there may be even some case law that would support the fact that you might have to go to a CFT, but you're pre-jurisdiction, you're
Right.
disposition, so they can't make you do anything. They can't order you to do
Okay.
anything. I was in another county not too long ago, and they wanted my client to be ordered to do drug testing. And before the judge could order it, I said, objection. We're pre-jurisdiction. Your Honor, with all due respect, you can't order anything. And the judge kind of looked at me and said, you're right. And I just got the feeling that in that particular courtroom, judges order stuff all the time pre-jurisdiction and nobody objects, but then therefore it's a valid order because you didn't object to it.
See, I didn't know that either, because they tried to order us to hair follicle, which we told them, no, you can't do that. But they've still ordered my child to be hair follicled, even though it's against my civil and it's against my religious beliefs.
Well, first of all, hair follicles are quote unquote illegal in California. So I don't know what, all of these places are doing hair follicles. And the funny thing is, and I spoke to a drug testing expert not too long ago who told me, and I didn't know this, who told me hair follicle tests are not more reliable than, say, your urinalysis. We just think they are, right? For whatever reason. It's an urban myth. Scientifically, hair follicles are not more reliable for a lot of reasons. And he explained it to me, and I was kind of surprised. And but people want you to do a hair follicle, mainly because hair follicles can go back so far. They can go back months. Urine tests can only go back like less than a week, because after a while it comes out of your system.
Right.
The most reliable drug test there is a blood test, but those are illegal as well. They're too evasive.
So what would they technically be allowed to do to test a child?
Well, they asked the court for permission to hair follicle test the kid. And since you're not the kid's attorney, I'm not sure you can really object to it.
Damn.
Right? So, it would have to be the kid's attorney. But hair follicle tests aren't what you think they are, because here's the thing, and I have this up on appeal right now. You have a hair follicle test, and the test takes place weeks after the event that you thought where the kid was or you were exposed to drugs. And what happens is there's no chain of custody as to environmental containtation. So
exactly. They took my child the day before.
Under a case called Kelly Fry, you have to prove the chain of custody. And when you take a hair follicle test, weeks later or months later, as in the case I'm involved in, there's no chain of custody. It's just assumed.
Right.
And therefore, if it's assumed, it's not admissible. That's going to be an issue. That's going to be an issue on a case I'm doing up in Northern California, just south of where you are, in the next few months. So we'll see what the court says. All right.
Well,
Any other
thank
questions
you.
for me?
No, I'm just trying to stay positive. I'm hoping, since this guy's whole testimony is a little different than what the reporting social worker said, and with all my professionals, I got my fingers crossed that they're going to return my child next month.
You know what's interesting
I'm
is
hoping.
that I'm going to tell you something that I found, unfortunately, throughout my career. Social workers will say that a witness said ABC. 9 times out of 10, you and your attorney will never bring that witness to court to be cross-examined. So everyone accepts that the witness says ABC. But sometimes when you bring the witness to court, the witness says, I never said that. Did you ever talk to the social worker?
Right.
Yeah. Yes, I talked to the social worker, but that's not what I told her. And then it's like, oh my God, the social worker must have lied. Well, that couldn't have happened. Social workers don't lie, do they? I want to tell you a case, and I lost
Yeah.
this case. This is about 15 years ago. A social worker reported that a witness, a therapist, said ABC. Okay, and that the social worker talked to her on such and such a date. Okay, well, my client kept telling me the therapist never would have said that. The therapist never would have said that. And finally, I said, okay, well, we're going to subpoena in the therapist. I subpoenaed in the therapist, and I said, hey, did you ever tell the social worker ABC? She says, no, I never told the social worker that. She said, as a matter of fact, I've never even talked to the social worker. I said, you've never talked
The
to the
same
social
thing happened with my therapist.
I said, the social worker you never talked to the therapist? I mean, to the social worker? No. I said, did you ever email with the therapist? No. Did you ever text with the social worker? No. I said, you've never communicated with this social worker? No. I said, did you know in this report the social worker said that she communicated with you and that you told her ABC? She said, that's not true. And surprisingly, although the judge never ruled on that specifically, I still lost.
Wow.
I wanted to appeal it, but my client was so distraught that she gave up. And that's what happens in a lot of these cases. People just emotionally give up.
I feel it.
So if a social worker says, a witness says something, the least you or your attorney should do is call up the witness and say, hey man, did you tell the social worker this? Well, yes, I did.
Okay.
Or it's going to be,
That's why we.
or it's going to be, no, that's not exactly what I said. Or I never talked to the social worker.
Right.
Social workers are so used to you not doing a trial and not calling a witness to testify. You see how they're trying to keep your witnesses out? You see how they're trying to do that?
Because they can back my story saying it was a seizure,
Right.
which it was.
Exactly. They're not used to having to prove their case. They're not used to people challenging. That's why I say, if you're really telling me the truth, all right, let's bring in the witnesses and have them testify.
Exactly. I agree on that. I watch your videos. I'm trying to take notes and make sure I make my attorney do her job because I don't have my money for my own. So I threatened her with the California State Bar and she got to it.
I'm not sure that's not how you make friends and
Practice
influence
goes a long
people.
ways.
But all
No,
right.
but I want my baby home.
I understand. All right, Tessa, I'm gonna have to sign off now. I have to actually get back into a courtroom online. So good luck with your trial. Keep me posted, okay?
Thank you so much, Mr. Davis. You have a great afternoon.
You too. Bye-bye.